Thanks very much. Thank you for having me and for a really kind introduction as well. I'm conscious that the lawyers get a rep for being the Eeyore in the room, so I promise to try not to do that. I'm going to try and focus on, as a nice segue from actually Pamela, Suzanne and Trish having covered the really complex stuff of the EU AI Act, easy for you to say, into some of a bit of more of a deep dive on the potential biases and how we can interrupt that, and particularly what we can do to kind of prevent that, what we can do to harness AI tools in recruitment without having all of those risks or in a way that mitigates those risks. So I'll try not to be an Eeyore. Two other promises: almost lunchtime, I can hear stomachs rumbling, so I'll stick to time. And I'll try to keep it light on the law, even though it's been called risk and legal ramifications, which I'm not sure I quite understand. Right, so we should start with how AI is being used in recruitment. We've had a really good grounding in this, actually, because you'll see that one of the main use cases is analyzing video interviews, and we've just had an amazing case study on that. So that's a really big use case. Increasingly prevalent targeting job ads, and it might not be initially very obvious why that is a use of AI in recruitment, but it's increasingly common for recruitment platforms, including social media platforms like LinkedIn, to offer targeting of job ads based on AI audiences. So design who you want to reach with this ads. And of course, there is inbuilt bias in all of us, in all of the hiring managers, and that can translate into your audience for ads. So right through from adverts, through to onboarding new joiners, through to kind of chatbots that support candidates through the recruitment journey, through to some, I'm not going to use the word creepy, but some slightly more overbearing systems around predicting fit. And again, we kind of touched on that. Those can seem jarring, but they're really about, for example, capturing candidates who have the kind of key skills that are identified in job descriptions. Always worth having a checking out what's on the market. So I commend to you, go and have a look at Eightfold's website, go and have a look at HireVue's website, and have a look at what these techniques look like. Also, it's important to say there are lots of really good D&I tools in this space, so kind of disruptive tools that help you recruit more diverse candidates or in a more inclusive ways. So, check those out too. Right, that's the grounding of the tools. How might bias creep in? Well, I think I'm in a room with an audience who are probably more informed on this than me, so I'm going to keep it really straightforward. It's probably quite well known, but bias can infiltrate these kind of tools in various ways. And the most obvious is the bias training data. So the idea that you ingest data which reinforces historic biases, predominantly from humans who make hiring decisions, which are biased, and that tend to lack diversity, or actually kind of other training data, so broader sets of data that are ingested, which reflect kind of global ethnic majority populations, and therefore maybe predict that those will be more successful as an outcome in recruitment. The really famous example of that, we actually had a chat about this on our table earlier, is the Amazon CV screening tool. You might all have heard of it, but it basically ingested a lot of data, CV data from previous successful candidates for warehousing jobs, and predicted that men would be good at that job, so effectively hired kind of only men, and had to be very promptly withdrawn. There's kind of algorithmic bias, so the algorithm in itself might be designed in a way that favors certain groups, and the video analysis tool that the guys talk through is probably quite a good example of that. There are feedback loops. It's kind of a risk of entrenching data, right? We go round in circles and make everything a bit more biased. And then the particular bias in video analysis. And one thing to call out there, if you want to do a quick Google later in the day, is there's an Uber case in the English Employment Tribunals, Uber and Manjang, that's recently settled. And that was all about biases in systems that use facial recognition technology, and the problem that gives rise to in respect of kind of reliability when it comes to potential racial biases. So really interesting ones to check out there. Okay, what are the key legal issues to consider then? I'm just going to keep an eye on time. So the big ticket thing that I want to talk to here is discrimination. And as I say, really good segue from the previous sessions, because while fairness is baked into the EU AI Act, there's a lot that kind of local equality legislation in the UK, Ireland and beyond can do to fill in the blanks there. And actually, there are standalone claims that might happen if you adopt or use or roll out a discriminatory or biased AI tool in recruitment. And the key thing around discrimination in the UK and Ireland, and broadly it's similar across Europe, don't quote me on that, is what gets a claim off the ground? Well, first of all, it's a kind of lack of explanation. So if an employer can't explain how decisions are being made, that's kind of black box versus glass box stuff, then you're on the back foot in terms of defending discrimination claims. And in terms of predicting success of claims, well, it is up to the candidate who says, I wasn't served that job ad, or I wasn't progressed through that stage of the recruitment process because of something arising from my race or nationality or disability, for example. It's up to them to show that there may have been bias or discrimination in there, but that's a really easy hurdle to show. And in a land of kind of AI tools, that basically just requires them to show that the candidates who got through that particular stage were underrepresented in terms of their protected group, in terms of their particular disability, for example. And then it's over to you, it's over to the would-be employer to show why it was not discriminatory. So statistics, you can get a discrimination claim in this world off the ground based on statistics, essentially. It is, I mean, there is some hopeful stuff here, and I'll come back to this very briefly in a second, but the other things that can help in terms of defending that kind of claim are showing that there is more transparency, showing that you've done your vendor due diligence, that your kind of vendor bias impact assessments have been ingested and looked at and pored over. And frankly, there's no substitute for really good situational training for hiring managers who are going to deploy these tools. So they understand both the tools and they can explain them, but also the potential bias impact of them. I'm going to very briefly gloss over potential data protection claims, particularly in the UK, but again, this applies beyond the UK. There is a bit of a loop here in that the GDPR requires processing of data that's lawful and fair. Well, it's not lawful if it breaches discrimination principles. So in a way, you can be hit in two fell swoops, a data protection claim or report to the ICO or equivalent and a standalone claim by the applicant themselves. The other things to look at in terms of legal issues, what does the contract say? This is more about who stomachs the liability, who stumps up. Is it the vendor, is it the user, the deployer, or is it someone else? Clear governance and structures, we've kind of been over that in an AI Act sense, so I'm going to quickly go through that. And then, of course, this risk of reputational harm. You know, the reason I've picked the recruitment space to talk to today is that is where there's a prevalence of tools, and there's a prevalence of tools that have, frankly, been deployed without much thought. The kind of Amazon example I touched on earlier is a good one, and that's done real reputational harm to employers. It's probably cost them good candidates, but it's also cost them in terms of how they're perceived on the market more generally. So, how do we fix it? Compliance and auditing, won't surprise you to hear that. We've been hearing a bit about that already. Two key things to say on auditing. One is, if you're procuring a system like this, you should expect your vendor to have done some bias auditing themselves, and you should want to see that and keep seeing it on a continuous basis. This is a continuous loop of improvement. And so if you're procuring these systems, if you're supplying these systems, you should be carrying out those audits. If you're procuring them, then you should be looking at them as well. But actually, to the third bullet point, you should be carrying out your own types of audits and risk assessments. And I know it's really dull when lawyers talk about risk assessments, but I promise this is quite useful. I've linked out in the slides, which you'll hopefully get, the algorithmic impact assessment template that the Ada Lovelace Institute came up with. It's a couple of years old now, but it's really, really useful. Very long, could probably be cut down if you're going to use it. But it's a really good starting point because, frankly, half the battle with this stuff tends to be, well, what should I be thinking through systematically? And you've got a template that does that for you and kind of prompts you to have these thoughts. One very quick point on jurisdictional differences. Compliance, particularly with equality laws, can vary. The expected standard when it comes to equality and non-discrimination, that varies wildly in different territories or different jurisdictions. So, for example, there is an element of latency or acceptance of a certain relatively minimal risk of bias in these types of systems in most states in the US, including in New York, where they've kind of fairly publicly adopted standards around this. That latency doesn't exist in the legal framework for the UK and Ireland and broadly Europe as well. So you could find yourself, if you're not careful, relying on vendor DD and vendor bias audits that are created to comply with New York law as an example, but which don't get you home in terms of defending discrimination claims here. So that's why the third bullet point is you should be doing your own auditing, you should be doing your own impact assessments. One other what I think is helpful, and what I think is like hugely surprisingly helpful, government guidance. It's actionable, it's sensible, it's in normal people language, which is just so rare when it comes to government guidance. So we've touched on how the UK government has potentially there's a bit of confusion about what their strategy to legislate for AI is. But what they have done well is publish this responsible AI and recruitment guidance. It's really good. As you might expect, it's principles-based, and the key principles are there, and you'll note huge overlaps with what the AI Act requires. So explainability, transparency, fairness, accountability and governance, all of that good stuff, and contestability and redress. So the opportunity for a candidate to say, I don't like that output. Can you explain to me why it happened? And can you give me a kind of human decision on my candidacy? But beyond that, it talks about best practices, and that's kind of where the value lies. So, for example, when it comes to fairness and non-discrimination, it's about implementing measures to detect and mitigate bias, and there's some actually actionable suggestions within it. On transparency, crucially, is transparency about the fact of the use of AI in the recruitment process, but more importantly, what the tool is doing, kind of what decisions it's influencing and how. And that goes back to explainability as well. Accountability, you won't be surprised to hear me, a lawyer, say, keep lots of records, keep all of your impact assessments. But that's really important because the way in which this principles-based legislation always works is a regulator will come to you and say, show us your workings. It's a bit like GCSE maths. You can get method marks. So keep all of that. And on data protection as well, is one of the themes, making sure that you're doing sensible things like data protection impact assessments. You're making sure there's a human in the loop. Again, back to some of the both ethical principles and the AI Act requirements. I'm conscious of time. I'll draw out one quick takeaway from this, which is situational training. I know I talked about training already, but the hiring managers who are going to deploy and rely on some of these tools, they need to know what it is, what it decides, how it decides it, how they influence that, or what the talent acquisition team does with that information. And they need to be able to explain that in human to candidates who push back. So training is really important. The other thing they need to do is speak to how bias has been interrupted in the whole process. And then I'm just going to leave this last slide kind of with you. The only two things I'll pull out is to say, you can see how many, and this is looking at it from the perspective of someone procuring or buying an AI tool or introducing it. The number of kind of people and teams that really should be drawn into this at an early stage is what the top bit says. And then the other bit is this kind of third-party evaluation. So the idea that there is value in having an outsider audit what you're doing to kind of confirm what you hope is the case after doing your impact assessments around bias. So that was a really quick whistle-stop tour around potential bias in recruitment systems. Really happy to chat this over more, so do, if you want, add me on LinkedIn, reach out if that would be helpful. But I'm conscious that we're now 1 minute into lunchtime, so I'm going to be quiet. Thanks very much.